on, people? All right, so this is going to be part, I think, 5 of this series. Point of View online, great publication if you want to search things about case law, what cops use, what cops can do. Point of View is a publication put up by the Alameda District Attorney's Office. They do a fantastic job on explaining case law that affects police and police powers. They were my go-to when I was working. I was first name and knew and friends with the guy who actually did this, the attorney, because I was always calling him with some, he goes, dude, you getting some crazy cases. But we became friends. He's a good guy. Anyway, here we go. Robey? We'll say Robey. I don't know. Robey versus Superior Court. Let's see how we're going to start this here. If officers have probable cause to believe that a package in their possession contains evidence of a crime, does the mobility of the package constitute an exigent circumstance that justifies warrantless search? Now, a lot of times people think exigency only pertains to entering a house. Exigency is any emergency where cops have to act immediately. But it's still, by covering this exigent circumstance, all these videos are going to get you in the mindset to get you to critically think. When you hear somebody talk about exigency, you're going to think about all the complex issues that can and do arise and how can the courts interpret it. Every time I acted out there, I was always reevaluating and how can I clean this up and make it better when it goes to court, and how can I make sure it looks good in front of the jury, and how am I following the law and make sure that I'm following the law, and how can I articulate why I did what I did and how I was following the law when I did what I did. So for good cops, now most cops out there responding to calls don't have to do that because they're not dealing with, trickery and wiretaps and search warrants and all this other crap. So because they're working just straight patrol. And when you're working patrol, hey, you shag calls. You're a license plate chaser or whatever. Basically, you go out there and you respond to calls. And you may self-initiate a stop every once in a while. You may grab a little dope, but you're not doing a whole bunch of warrants, task force, staking out, following people, surveillance, video surveillance, getting a plane to fly by so you can follow or take pictures. They're not involved in a lot of that on your regular duties. So this is almost like a specialty area. Like I said, most cops get, hey, if it's an emergency and you think you need to act, use good judgment, and the courts will protect you. You can't get sued. Do what you need to do and let the courts figure it out. And that's kind of how cops get trained in exigency. All right, here we go. If officers have probable cause, now they're saying probable cause. They're not saying reasonable suspicion, articulable suspicion, facts or circumstances that might indicate a possible, they're saying probable cause. Probable cause is those set of facts and circumstances that would lead a reasonable person or officer to believe a crime has been committed and the person you're arresting or charging has committed that crime. So probable cause is a little bit higher standard. If officers have probable cause to believe that a package in their possession, how did it get in their possession? Is it in their possession because they got a warrant, or is it in their possession because they snagged it or because they found it in a public place? Those are questions that need to be asked. In their possession contains evidence of a crime. Does the mobility of that package constitute an exigent circumstance that justifies a warrantless search of the package? Look, anytime as a cop, for me to err on the side of safety, if it was in my possession, I'm going to go get a warrant. It makes it clean. I tell that story to where I was trying to hack in to this girl's email account because I knew her daughter was emailing her friends, and I started doing passwords that I would commonly think kids use, and I end up getting in her account by accident, just trying. Well, that's a crime unless I'm working an investigation, I'm working for government. Of course, the DA has to charge me for that crime, and I was working for the DA's office doing it, so I wasn't charged for any crime, but I was just trying to hack in and get information. Well, as soon as I got in her account, I went, oh shit, I'm in. So instead of reading all her stuff, I literally opened up every email, printed out a copy, hit print, open, hit print, open, hit print, because I got in there really quick. I didn't want her to try and access her account while I was in there. And since I didn't have a court order to go on her account, I was like, shit, I don't have justification to read her shit. Even though if I read it and I used it, nothing would happen to me. It was just wrong, and I didn't want to do it. So I just printed all her shit, and then I put it in a package, And I sent it to the courts, and I went to the judge, and I said, I want a warrant to read the shit. And when I got the DA to sign off on it, he goes, what do the emails say? I go, I don't know. I didn't read it. And he smiled. I go, I didn't read it. He goes, okay. And he signed it. Like he knew I read it, but I was saying I didn't read it. I really didn't read it. I opened it up and I hit print, and I was doing it so damn fast I didn't have a chance to read it. And when I went to the printer, I collected all the shit and I put it in an envelope because that was the right thing to do. That was complying with the law. So when I took it to the judge, and he goes, what's an email? Is it going to help you? I go, I don't know. I haven't read it. And he looked at me and smiled. And I went, why does everybody smile when I say it? I go, Judge, I didn't read it. He goes, why didn't you read it? I said, because I didn't want to lose it, or if I found something, I thought it was unlawful because I went in there. And I said, you know what? Just to be on the side of safety, I'm going to print it. I'm going to get off her account, and I'm going to get a court order to read the stuff that I printed. And then in a court order also, I want to go back in her account, and I want to be able to use her password to get in her account. And he signed a warrant, and I got the warrant, and I went and read. He goes, let me know what it says. I go, all right, I'll let you know. And I went back, and we got some information, ended up helping us find these kids that were abducted. So, but again, I always try to act in the spirit and intent and within the law. Even though some may say you had no business trying to get in her account, I was at a lost end. I was losing this kid, and I was like, you know what? Let me just try some passwords. What the hell? I'm sitting behind my desk here. I'm getting paid by the taxpayers. I ought to do something. Other people would say I should have never tried to password. Now, could I have went to the court, got a search warrant, and said, I want to try and hack into her account and guess her password? I could have. Looking back, maybe I should have. That would have made it cleaner. But when I was doing it, I'm sitting here, I had no idea I was going to get in there. So when it happened, it surprised me. But anyway, I digress. Let's get back to this one. Package, exigent circumstance justifies warrant. If something's in my possession, I'm getting a warrant. I'm not opening it. But we'll see what they did here. Facts. A FedEx employee, freaking little snitch, FedEx working for the government. A FedEx employee notified police in Santa Maria that she could smell marijuana emanating from a package that had been dropped off for shipment. What is this? This woman running around smelling packages? What does she do if she smells fish? She thinks woman's underwear is in there? What the hell? What is she doing? Whatever. All right. The odor was so strong that the responding officer could smell it from 25 feet away. Now, I will say that women have better noses than men's. I know that's probably sexist, and the left-wing rainbow police will be crazy because I said something like that. But because I said it's a good thing for a woman to have better smell, maybe they won't have a problem with it. But anyway, women tend to have a better sense of smell than men. I don't know what it is. Some people relate it to, mamas can smell their babies in a herd of 50, cattle or zebra or whatever. They can smell their own baby, and their sense of smell needs to be greater. And that's why. I don't know if that's true or not. Whatever. All right. The employee said, Rick, why don't you stay on subject? Because shut up, you freaking crybabies, because it's my freaking video. All right. The employee said that FedEx would not deliver a package containing drugs. So is FedEx making a determination that it's drugs? This smell of marijuana shit's bullshit. Marijuana smells like 50 different things. We used to be asked all the time, what does marijuana smell like? It smells like marijuana. And that's what we were coached by the DAs and by attorneys to say. You guys need to quit saying it smells like skunk, it smells like popcorn, because you're making it harder for us to prosecute. It needs to smell like marijuana. So all cops were briefed. When you say, what does marijuana smell like? It smells like marijuana. Like it has a unique smell. There's different brands, there are different flavors, there are different cuts. Some people put dust on it, some people put hash oil on it, some people put hair. I mean, there's different ways to make marijuana smell different. But for court purposes, if we smell marijuana, we were told to say, it smells like marijuana. Anyway, I digress. The employee said that FedEx did not deliver the package containing drugs. So the officer took it to the police station. Okay, I've got a problem with the officers taking this package from FedEx. Now, it could be argued, and I might take it. I'm not sure if I would take it or not. It could be argued that FedEx had possession of the package. And since it was given to them to ship and it was in their possession, they had care, custody, and control of the package. Therefore, if they wanted to voluntarily give it to me as the government, they are allowed to do that. That would be the argument that I think I would make if I took this. But I would still have to think about it, and I may want to call an attorney and go, hey, should I take this or should I get a warrant? Because she's saying it, and I'm sure the DA would be like, you don't need no warrant. She's got custody of it. Just take it. She's giving it to you. She's giving you consent, right? It's her package because she has possession of it. Well, it's actually not her package. It's the package that sent it that paid them to deliver it. They didn't pay them to freaking keep it. They didn't pay them to give it to the cops, and they didn't pay them saying you can open it. They paid them to deliver it. So I would argue that they may have limited possession, but they don't have care, custody, and control and the ability to open a package or to give it to the government. From me, my anti-government state, that's what I would argue. But for the sake of this, the cops took it. When they took it to the station, it was open without a warrant. Bad move. At a minimum, even if I did take it, I would have got a warrant and said, I don't want to risk this. Because what happens, let's say they open it and they find a little bit of drugs, and these drugs lead us to the person's house, and then we go to the house and we find out there was a murder and that there's people buried in the backyard, and we find guns or we find classified material that was about to be sold to the Russian. We just can screw up everybody's case if we go there now and we lose the ability because we open it because we didn't get a warrant, and now it leads us to all this other fruit from the tree of us opening this package, and we lose it because the tree was poisonous because we had no business opening the package. Fruits of the poison tree doctrine. Most people know that. But anyway. All right, here we go. Inside, officers found 444 grams. Holy shit. Man, jackpot. Marijuana. We solved the crime of the century of marijuana. Robey was arrested when he returned to FedEx office to find out why his package hadn't been delivered. Robey's an idiot. If you're sending drugs and your package is delivered, if you go claim it and search for it, you pretty much prove possession, intent. You're the one that shipped it. It's your package. You make our cases strong. Good job, Robey. Thanks for making cops' case stronger. Anyway, they arrested him when he returned to FedEx to find his package hadn't been delivered. The trial court denied Robey's motion to suppress the evidence, but the Court of Appeals ruled the search was illegal. I agree with the Court of Appeals. The trial judge just supported the cops. The Court of Appeals said no. I don't know why they said no, but we'll find out. Illegal because the officers had not obtained a warrant. Well, I would agree. The Santa Barbara DA's office appealed to the California Supreme Court because the DA didn't want to lose the case. If the cops would have just went and got a warrant, they wouldn't have lost it. That's why I always tell cops, dude, when in doubt, get a warrant. Don't fuck around with if, and, buts, and coconuts. That'll probably be okay. Just go get a freaking warrant. Once you get a warrant, everything is golden. You had a DA review your probable cause. You had a judge review it. They both signed it. They both have immunity. You have immunity, and you won't lose the case. It's very hard to lose evidence seized by a warrant. It's almost damn near impossible unless you get caught lying in a warrant. Then you can lose the warrant. All right. The DA argued that the officers did not need a warrant, one, because they had probable cause to believe the package contained marijuana. The probable cause is what they're saying is a person said they smelled marijuana. I didn't read anywhere where the officer said, I smelled it. If I wanted to open this and I was going to use probable cause, I would say, if it was my case, I'd be like, okay, so the employee said it smells like marijuana. It smells like marijuana to me. Let's get a dog to run by it and respond on it, because then he can confirm that he smells marijuana. Let's get the head DA task force that smelled thousands of marijuana cases that they've done, because that's all they freaking do. And let's ask them if they think it smells like marijuana. The stronger you make your probable cause, now when you open it, the less chance they're going to say, it was just an employee that did it. You can't open a package on an employee. It was just an employee and you. Maybe you had a cold that day. Were you on medication? Do you have sinus problems? Have you ever had sinus problems? Do you take sinus medication? The pollen count was high that day. How do you know your nose was smelling it? How do you know somebody with marijuana didn't handle the package and what you were actually smelling was the marijuana on the outside of the package and there was nothing in there? See, the problem is if there was nothing in there, we would not be here. That's why when people get here, they're like, oh, it's okay, the cops are good. The problem is, how many times did the cops do this and it wasn't marijuana and they violated somebody's rights and they did this? Because there's no duty anywhere for government to report when they fuck up. But I digress. I'm sorry. I said the F word. When they screw up. All right. So the DA says, one, they had probable cause to believe the package contained marijuana, and two, there were exigent circumstances. Ooh, exigency. I like it. Let's hear how they're going to spin this. Specifically, a package can be easily moved and might therefore be lost or destroyed. Can you believe a DA is actually saying that he thought because the package could be removed, that created an exigency that they didn't need a warrant? That's just absolutely flat out lying. You got possession of the package. What do you mean it can be moved? It can move from the evidence room to the courthouse? You have possession of the package. How the hell can a DA with a straight face go back and say we were concerned about the package being moved and therefore we had exigency to open it? That is what I call reaching. If I see a DA preparing something like this for my case, I'll be like, dude, that's some weak ass shit. Really, you're going to go there? He goes, hey man, you throw it up there, you never know, a judge might agree. So that's exactly what this DA did. The California Supreme Court seemed to agree with the DA that the officers had probable cause. Consequently, the main issue was whether the inherent mobility of the package containing the drugs or other evidence constituted an exigency. I say not no, but hell no, but we'll see. That justified a warrantless entry. Bullshit. They could have went and got a warrant. There is, in fact, a case from 1972, People v. McKinnon, in which the California Supreme Court ruled that such mobility does constitute an exigency. That's what they're using a lot for vehicles. When we have a vehicle and we smell marijuana, because the vehicle is so mobile, and once it leaves, the evidence could be destroyed, and therefore, we automatically, if we smell marijuana, we have a right to go in a vehicle. That's the premise behind that. I don't like it. I think it gives government too much power, and when you give too much power without accountability, you get tyrannical government. But anyway, I digress. But, as the court and Robey pointed out, McKinnon was based on a court's interpretation of the decision by the U.S. Supreme Court that the High Court has subsequently rejected. Thus, although McKinnon had not been expressly overturned prior to Robey, its validity was doubtful. Moreover, the Robey court noted that McKinney was based on dubious reasoning. So one court is saying the other court made a ruling, but we don't like their ruling because we think their ruling was dubious. Okay? So, as it was pointed out, the container that had been seized by the officer is no longer mobile in the sense that it was vulnerable to loss or contaminant. Correct. It was in police custody. As a result, there is no reason why officers could not simply take the package to the police station and apply for a warrant. I agree 100%. Consequently, the court ruled the police had no... What? I'm not even sure what... Let's see what derivative means. Rick, you should know. I'm reading these shit on the fly. I don't know what the hell they're talking about. Hell, it's not even up here. What is the derivative of zero? Derivative... What's the derivative of zero? The answer is... the derivative of zero is zero. That makes it because it's a what the hell does that have to do with drugs? Somebody give me a derivative. Oh, I have zero derivative. Sorry. Let's try this again. Derivative.
Derivative.
What does it mean? Derivative. Typically, an artist at work proved for that something that is based on another source. I'm not even sure that freaking word applies. More freaking crazy lawyer talk. No derivative authority to search the package later at the police station without a warrant. I agree. I would have just said, look, there was no exigency, there was no emergency, the package was secured by the police. Unless you're saying that the police are crooked and they're going to tamper with it, there is absolutely no reason that the cops can say we didn't have time to get a warrant. We had the object in our possession. Time was not a factor. Therefore, you're required to get a warrant. Don't pull exigency. That's what I would have preferred the court to say. There is, however, an exception to the rule. Oh, shit. Are you kidding me? As the court explained, an immediate search is permitted if there are unusual circumstances where transporting or storing a container poses a practical difficulties for law enforcement. What the hell does that mean? I'm thinking they're talking about maybe a bomb. If I have a bomb and I don't get a warrant and I want to see if it's a bomb, maybe I don't need a warrant to go get it because it poses a danger. I don't even know what the hell they're talking about. For example, they're going to give an example. A warrantless search would undoubtedly be permitted if officers had probable cause to believe that the package contained hazardous material or explosives. Okay, that's the first thing that came to mind. Hazardous material will be another one. If we kept it here, let's say it's fentanyl and it's going to maybe affect some people. Let's say it's decaying something that could be biohazard. I can agree that would be an exigency. I would agree with that. But because there was no such exigency in the circumstances of Robey, the court ruled the search was unlawful. Great. I love it. Uh-oh. We have a comment. Wow. Let's see if we can make this more confusing. We do not agree with the court's ruling. Well, no shit, because you want to win. That the opening of the package without a warrant was not justified. I absolutely agree, and who's ever writing this, I would say you're full of shit and you're too much for government power. But we do think a warrant was required because the contents of the package was self-evident, and therefore the opening of the package did not constitute a search. We do not think a warrant was required because the contents of the package were self-evident. I guess he means we knew it was marijuana because we could smell it. And therefore, the opening of the package did not constitute a search. Are you seriously trying to argue? This DA is freaking full of shit. All right, hopefully this ain't the guy my buddy that wrote this. Although this principle is commonly known as plain view, or has here plain smell, so they're saying, it sounds like they're associating, a cop can seize evidence in plain view. If I see something that looks like drugs, I can seize it, as long as I'm where a place I can be. They're saying, if I can smell something that I can absolutely, positively, 100% identify has marijuana, then I'm allowed to seize it. I might give them an inch here. That this is kind of a reasonable argument that kind of goes along with plain view. I just lost a lot of my viewers. Rick, you're a jackboot. You just said you didn't. This is why with more information you change your mind. This is why when people tell you the law is clear, it's never clear. It is also often expressed in terms of privacy expectations. That is, a search does not result if officers intruded into a place or thing in which a person did not have a reasonable expectation of privacy. That's true. The person has to have. Just like a screen door, I can look through it because there's no reasonable expectation that somebody can't see through it. But I can't open a solid door and look through it. But whatever it is called, its reasoning is pertinent to the case at hand. Specifically, if officers know that a package in their presence contains specific evidence of a crime, their act of opening it does not constitute a search because they were not looking for anything, nor were they trying to obtain further information about anything. They were simply retrieving what they knew to be inside. Man, this guy's lawyering the shit out of this, but it kind of makes a little bit of sense. I just don't like giving government the ability to manipulate on this if and buts and coconut shit. Okay, the U.S. Supreme Court seemed to have this principle in mind when it said in United States v. Johns, whether respondent ever had privacy interests in the package reeking of marijuana is debatable. Now, that is debatable. The person that sent this, knowing it smells like marijuana, can they claim a right to privacy that nobody can search this even though they know it's drugs? That's like me sending a package with a time clock clicking inside and saying, you can't open it, I have a right to privacy. Well, you sent something that's clicking inside and it's leaking some sort of moisture, and we see wires poking through the package. And you're saying, because you have a reasonable expectation of privacy, I can't further investigate this possible bomb. So this is why you need to understand when the courts rule on things, they're looking at the if and buts and coconuts, because you can't make, okay, cops can only go in a package if there's wires and there's ticking and there's this, because then you couldn't go it further. I mean, it's just, if a phone's ringing inside a package. All right, here we go. We have previously observed that certain containers may not support a reasonable expectation of privacy because their contents can be inferred from their outward appearance. Consequently, in determining whether officers had searched Robey's package, the following circumstances seem pertinent. The package contained that wasn't pertinent because we didn't know that. Not surprisingly, reeked of it. Okay, it smelled of marijuana. The odor was so strong that it was detected not by a canine or a sophisticated detection device, but by a FedEx employee at a drop-off. Yeah, but now, if you're going to use this as justification, you need to verify how this FedEx employee knows what marijuana smells like. Did she smoke marijuana? Did she sell marijuana? Does she live in a house with marijuana? How does she know? And what is her expertise in saying 100% this is marijuana? If you're going to use her as a reference or has probable cause, you have to establish what her expertise is. And they didn't do that. Not that I know of. Okay. 3, the officer detected the odor from 25 feet away. Okay, so now the officer who had trained in marijuana, we used to burn these little tabs that smelled like marijuana, and then the court started saying, look, you're training cops on something that smells like marijuana. They're not even being trained on real marijuana. And then we actually burned real marijuana, so when we got to court, we could say we actually smelled burning marijuana and marijuana before it was burnt. And it was real marijuana. It wasn't a tab. I don't even know if they even still have the tabs, but I digress. There's nothing in the record to indicate that Robey had taken any precautions to prevent the odor from escaping. Well, that doesn't matter. What? So you're saying if Robey would have put tape and put it in a coffee can and wrapped it around coffee, etc., then you wouldn't have probable cause? That has nothing to do with it. This is when judges and DAs try to get shit in that we find out later, kind of like 440 grams. We didn't know that at the time. We didn't know whether he took precautions to stop the smell. We only knew that afterwards. So that's what they're using justify, and you can't do that. But they're sliding it in like you can. Despite these facts, Justice Louis Goodwin, writing for the court, said, neither the district attorney nor the defense offered evidence that proved in depth or detail concerning the intensity or other qualities of the smell detected by the officers. And the record, in this case, the record meaning when you go to appeals, you can only go by the record. That's what the court reported type. The record in this case did not permit us to resolve the privacy issue one way or the other. But it is hard to imagine what more depth or detail was necessary or even possible. Acknowledged that marijuana has a distinct odor, and today, 28 years later, its odor has become universally recognized as popcorn. Really? If the court ruled that marijuana smells like popcorn, then no cop can ever search a car when he says he smells marijuana because he could be smelling popcorn. If this is true, and I don't know whether it is, maybe I have to look that up. Hang on. Okay, I looked up U.S. Supreme Court 28 years ago, recognized popcorn. I can't find it. Anybody finds that case, put it in the comments. I also looked up this notorious stayed justices, and I'm like, the hell is stayed? Here it is. Stayed.
Stayed. Stayed.
Stayed. Stayed. Sedated. Respectable. Unadventurous. What? Sedated? What? Quite? Serious? Respectable? We still talking about judges? Okay, so we're going to end that there on this one. Again, exigency is never clear. The law is never cleared. You need to understand the issues that the courts address when they're addressing your issues. And one court will get overturned, and then that court will get overturned, and another court. So the law is not the law, and I keep trying to tell people that, and the idiots on the internet are out there. Man, I know the law. You don't know what you're talking about. The Supreme Court and the Constitution. Whatever. Come on, people. Get with it. We'll end that there. Hopefully you got something out of it.